I don't know if you know about Portland at the neighborhood level. Our beneficent city has bestowed upon us the ability to make tiny little decisions about liquor license laws and zoning things within our little 95 neighborhood associations. And I wonder if perhaps something like the community rights strategy could be used at the neighborhood level, if something were strong enough to polarize people on that small, maybe it could just be one issue. I'm just curious what you think about that.
Yeah, in fact, what you're describing is what Spokane went through. We have 27 neighborhood councils that are actually recognized by the city, so it's broken up into districts. And what those neighborhood activists drafted for the ballot was was that if significant new development was occurring, commercial, industrial, they applied in other ways, to get a zoning variance, in other words, to change the zoning to allow that new construction to come in, that required the approval of a majority of people within the neighborhood. And so it freaked the homeowners out, it freaked the Chamber of Commerce out.
So did the majority have to participate in the vote in order for that to be enacted?
No, just majority.
Those who voted.
Actually, a majority of registered voters within the neighborhood. So it's not a higher bar than that. But it also said that no zoning variance would be effective unless they have the majority approval of the neighborhood. And so you can imagine in Spokane, which is a big home builder's place, that it freaked a lot of people out. But also in New York City, the plan that we're working with, I don't think it's secret, it may or may not happen, but the fact is they want to give the power to the boroughs and borough community groups, which have been recognized under the Charter of New York, with power to actually stop pipelines and stop fossil fuel conveyances and other things within the city. And so this democratization now, there's a relationship of your neighborhoods probably, and Spokane neighborhoods to the city itself, to the municipal corporation. It's almost identical to the relationship between the municipality and the state, and that's the parent-child. And so, the neighborhood council's neighborhood units are children, and the city is the parent. And generally, the neighborhoods only have advisory power over certain things. They can comment, they can do this or that. In terms of binding decisions, in most places that doesn't exist. And so this is about people at even those subunits rising up and saying, hey, we want to decide what the future of our community looks like. And in Spokane, that's the direction we're taking.
Thank you.
Hi there. Could you speak a little bit more about you talked about this rights-based model, and then you also talked about the rights that the corporations clothe themselves in, right? Preemption and so forth. Can you take us a little bit further about now you have these rights-based ordinances around 138, I think you said. Where do you anticipate and how do you anticipate the corporations are going to react using these other rights that they have?
Well, yeah, you're seeing that now, and they're getting much better. They're learning, they have a learning curve as well, just like our learning curve. And so in Oregon, even though very few places have even contemplated banning GMOs or doing GMO stuff, they're already active in getting the legislature to move. And so in addition to that, we've also had a bunch of pre-election ballot challenges. They're now trying to keep initiatives off the ballot because they understand we're trying to get them into a fight where a majority of the community votes something in, and then that faces off against the corporate rights stuff. So they're trying to change the landscape now. In Benton and Lane, the Oregon's tough in some ways because even before you can circulate a petition in the rural county or in any county, you have to get the approval of the county to do so. And there's a test that the county attorney can apply to try to keep it off the ballot. That's happened in Benton and Lane County already, and we've had to sue both. So there's two active lawsuits right now against Benton County and Lane County. The county attorney and the county clerk refusing to certify the thing for circulation. So here in Oregon, it's like the death of birth. You can't even get past the first stage. And in one of those counties, in Benton, you had an intervention by an agribusiness guy. So the main Oregon organization dealing anti-GMO stuff has attempted to intervene, hadn't intervened in the last case, and now attempted to again, and fought him off, and now he's back. So they're starting to intervene earlier and earlier in the process. And I think that's a good thing because it makes it a voting issue at that point. It's not even about the issue. You may agree or disagree with GMO stuff, but at least we should vote on it. And now we're coming to a point where people aren't even being allowed to vote on it. It's being stopped before it's out. And I think that exercise of corporate control is very eye-opening to people. And in fact, in Spokane, where they sued to keep the initiative off the ballot this time, because it came so close to passing last time, they want to keep it off this time. Tim And so you have this weird overlap of political stuff, where some of the conservatives are in the same boat, because they want to get their stuff on the ballot, and the corporate boards are using the same stuff to keep along. And so now you see a kind of joined, a limited scenario to try to fight that stuff off. And in fact, there's a statewide initiative in Washington that we voted on in November to get rid of all pre-election challenges to ballot initiatives, actually eliminate them completely. And it's been run by Tim Hyman and those guys. And now we find ourselves in Spokane supporting it and actually trying to get the vote out for it to stop the interference that's occurring with these initiatives. So,
You mentioned of documenting factory farming and defining it as terrorism to take pictures. So I wonder if you've had much crossing over with your groups, with activist groups, which are trying to document the things that these organizations are opposed to.
yes, one thing we haven't, but it could easily be extended into that. But we have to contact by with that specific issue. Most folks go after the whole structure or facilities themselves rather than the documentation stuff. But I've heard those.
And then data ownership and data privacy. I wonder if there's any movement like the Electronic Freedom Frontier, EFF, or Lawrence Lessig, or any of those groups to identify rights of citizens and their personal information and data.
Yeah, that swallowed about 2 months of my life trying to make the case to those guys that they should be doing something along those lines. But they haven't gone in that direction. They don't understand the need to go in that direction. And so we settled for a Seattle initiative that folks tried to qualify, which was about internet privacy, internet access, and freedom of the internet. In essence, Bill of Rights for the internet stuff.
At the city level?
At the city level. And it didn't qualify because there wasn't really a group there to qualify. But that was our only foray into that kind of stuff. We're now getting calls on drones and the same stuff. And so we probably branching off in other directions as well.
Well, nuclear power is the big one for me, and I wonder if you might be familiar with the Richmond Power Generation Facility and Vermont Yankees licensure struggle, and I wonder, since they've relicensed Richmond for another 30 or 40 years, and Vermont Yankee actually went to the Supreme Court, and they decided that the state couldn't tell Vermont Yankee that they couldn't run their nuclear power station,
Yes.
and then because of economic reasons, they decided not to. So what about all those people downwind, down Columbia, who have community rights that are being violated by Hanford?
Haven't called. I mean, they haven't yet, but that's a perfect organizing platform because there's no remedies for those folks. And in fact, I thank you for talking about the Vermont Yankee case that way because that's exactly how it happened. But the day after, for economic reasons, that the corporation decided to shut the doors.
But the Supreme Court decided that the state had no right to stop the nuclear power facility from operating.
Yes, but that gets hidden because the progressive liberal activists who have been fighting years over Vermont Yankee claimed it as a victory. When in reality, it was the corporation deciding unilaterally that they were going to leave the state. And so it's still a loss because the court said you have no power within the state of Vermont to actually control nuclear plants within your borders. And yet it was claimed as a victory by the progressive liberals who said, well, it's a victory because we've now closed down Vermont Yankee. And nothing could be further from the truth. I mean, they're good people on the front lines, but at the same time, one was not the cause of the other.
It just seems like all these communities downstream from Hanford should have claims or rights that are being...
Or laws that create the structural liability or create rights of nature as well in those communities. I mean, all that stuff has to be on the board because right now it's just we give them a pass on it pretty much. Yeah.
If all of the legal strategies fail that we can bring to bear, the construction is going to start, and the only way to stop it is for there to be a sufficient number of people physically present, civil disobedience physically blocking that. People have lives, people have jobs, people get tired. Do you have any thoughts about those kinds of situations?
No. I mean, the thoughts I have is that we always hear people saying, well, if I think something, I'm gonna lie down in front of a bulldozer, I'm gonna do this or that. Maybe Portland's different, maybe it is, I don't know, but it never happens. It's like when it gets to that stage and everything's been exhausted and remedies have been pursued and ungotten, that people just accept it. I mean, it's weird that way to me, because if it was my community, I probably would be out there. But the criminal justice system is such that it crashes down on most people. I mean, the law, the enforcement, everything else on the other side. What this work is about is doing civil disobedience collectively. So then we're actually seizing municipalities collectively to break the law. But this work is about breaking the law. It's about recognizing the law and breaking it. And so in terms of imminent harm, there's going to be tons more imminent harm that come down our path that we're not able to stop. The question is, can we organize to aim at the larger stuff to actually stop it from happening again? I mean, in the talks I gave last night in Iowa, today it's fracking, tomorrow it's glacking, and then we have whacking, and then we have shellacking, and then we have, backing. And the industry changes the terms. We're not fracking with diesel fuel, not water anymore, but diesel fuel. And, some places are not burning topsoil for energy, so I just learned. And so the fact is that they can change into multiple shapes. And we have to come to a point where we decide the issues that are relevant. They all come denominators, which doesn't matter what we want until we change the structure itself. And the question is how you go through it to actually change the structure.
Thank you so much. One last specific point. I'm so sorry. The ecosystem rights, to my mind, seems to carry about as much weight as corporate rights from a certain perspective. I fully support it, but I'm concerned about the logical fallibility of it, where we're saying corporations don't have rights that ecosystems do.
Well, in some ways, corporations are property. It's almost like your refrigerator having rights. So the system of law is either for living things or for property, but it can't be both. And so right now, corporations having rights are like your refrigerator as a piece of property having rights. It's inconsistent. It's intellectually inconsistent, also inconsistent from a bunch of other paths. And so on that one, indigenous peoples have always treated nature as something other than property. It's Western culture that has refused to accede to that because it fit the model of economic development that we needed to control nature and ecosystems. And so in some ways, it's just about taking indigenous values and driving them into the Western system of law. And in the 70s, a guy named Christopher Stone wrote a book called Should Trees Have Standing? About trees having standing to sue. Forests was picked up by a Supreme Court Justice, Justice Douglas, in a case called Sierra Club versus Morton. And so, the idea germinated way back when, but nothing was done with it. And now this is about people taking that up again and moving it. And I think that's very